Hello, I'm Angela Princeville, and I'm joined with Shirin Abdi. We are both family law lawyers at AP Lawyers, and today we're talking to you about what you must know before signing a separation agreement in Ontario. So, if you're thinking of getting a separation agreement, fantastic. You have to watch this video all the way to the end because we will be breaking down mistakes people make and how best to protect yourself. Okay, so starting point, what even is a separation agreement? Shirin, I'm going to let you kick this off.
Yeah, so a separation agreement is a legally binding contract between spouses, and the contract can cover a wide range of issues, including property division, spousal support, child support, parenting, debts. Basically, anything that needs to be resolved as a part of your separation can be dealt with in this contract, and it can be enforceable just like a court order.
Exactly. So that's an important one because people want to make sure that their agreements are possible. So that's great. But people often think, oh, well, we're just going to wing it, right? So you need to make sure that you're getting proper legal advice so that your agreement doesn't just fall apart. Now, you can use an online template. In fact, at our firm, we have a free downloadable template that we provide to people to use as a guide. And the idea is for you to use it as a guide, almost, I don't know, a conversation starter, maybe just to give you a pointer on which direction to go. Now you can use it in drafting your agreement and, sign off on it and make sure we'll talk more about the formal requirements in a bit. But you want to be careful because everyone's situation is unique, and we always advise that you get a lawyer to draft the agreement for you. But you can use our guide as just a guide to help you go through, have a conversation and try to come up with a settlement as amicably as possible. Because, of course, if you're doing a separation agreement, the idea is you want to get this done without having to go to court, and you want to make sure that you're protected in every area. So do use online templates. If you have one that's available to you, try to make sure it is specific to Ontario, because sometimes people include terms that are not Ontario specific, particularly maybe they're related to US law. So that could be an issue for you. And that's, of course, why we always propose having a lawyer draft it for you. But in any case, full financial disclosure is essential, right? What do you say, Shireen?
Absolutely. In my opinion, it should be non-negotiable. So it's something that you should think of immediately when you're discussing the finances. Full financial disclosure from both parties, which outlines their incomes, their assets, and their debts and liabilities from the date of marriage until the date of separation. And you want to be very clear what the other's financial circumstances are. And the reason why is that agreements can be set aside on the basis of lack of financial disclosure. So you definitely don't want to be in that situation. And a red flag often is where a party says, you know what, let's just keep it simple and just trust each other. No need to go through lawyers, no need to go through the disclosure. I know what you have, you know what I have, and that little sprinkle of jazz. No, that's a red flag.
No, absolutely. 100%. Well said, Shereen. Now, fairness, this is one that might be a little bit controversial because one party may be hoping to use the separation agreement as an opportunity to get an advantage. And hey, do you, but my advice is it's important for the agreement to at least be fair. If you want to make sure that it doesn't get set aside later. And we're talking fair in its procedure, and that means, we'll talk a little bit more about duress and things like that. But you want to make sure that, the process of getting there, if someone needs space, for example, to think things over, that you allow that. Shireen talked about financial disclosure. That's something you need to make sure that there's space to provide that before you draft the agreement so that it's fair. So that's the procedural fairness of it, and the substantive fairness of it as well is something you want to be careful with as well. So if you've been married for say 30 years and you're worth $5 million and you're giving the other side $500,000, well, you might, I mean, if there's a reason for that, you may need to explain that, right? I mean, Sharina, in our work, we often see people get very attached to the matrimonial home as an example. So if that's the reason why, the deal is a little bit lopsided because the other person wants a particular asset that matters, you want to thread very softly. So my thought is you want to make sure that when you're drafting this agreement, even though you're avoiding the courts, just think about the substance the substantive fairness of the agreement, and also the procedural fairness as well. Because if it looks extremely unfair, or if it looks like the other person was pressured into signing it or was taken advantage of, you may be opening up the agreement to the possibility of being overturned by a court later, right?
Absolutely. Another aspect is independent legal advice. Each party should really honestly have their own lawyer. There is no such thing as both of you retaining the same lawyer to represent your interests. They can't simply just cannot be done. And we get asked this question a lot. And the reality is it's not possible. It's a conflict of interest. And the reason is because I'm going to provide advice to one party that's going to be significantly different than the other, right? So in that scenario, each of you should have your own lawyer to represent your interests when dealing with the agreement. The part of legal advice really is to ascertain what your rights, entitlements, and make sure you really understand the terms of the agreement. Sometimes separation agreements include a lot of legal jargon. And sometimes people are just like, oh, this is what I understand this to be. And it's actually the exact opposite of what they
Yeah.
expect because they're just in their realm of their day to day. This is not language that they're used to, right? And that's fair. But it's important to have legal advice. It also protects you because it makes the agreement harder to challenge. And I know we've talked about different ways in which the agreement can be set aside or challenged, which is lack of disclosure. Another is independent legal advice. So you definitely want to make sure that you're getting proper legal advice and each of you have access to that.
Yeah, absolutely. And this goes to that procedural fairness, right? Just making sure that the person has an opportunity to get independent legal advice would really, make a whole world of difference. Now, um, if you have children, I think parenting and support are not optional topics for you. So you should address that, right? I mean, you can have partial agreement. So I don't want people to take kind of the wrong message from this. You can have a partial agreement that deals with, maybe property and other issues, maybe just even one topic. Sometimes people would enter into a partial agreement, just dealing with the sale of the matrimonial home and deal with other issues. But you haven't resolved all issues if you've not dealt with parenting and support. So when you're looking at things like child support, make sure you follow the guidelines. And as much as possible, try to avoid waiving child support. I often tell people if you have a shared parenting arrangement, don't assume that means there's no child support payable. Many people make that mistake, and it is so wrong. And I'm passionate about sending out this message because a lot of times when people come to us, they're owing, hundreds of thousands of dollars in some cases because they've gone 10, 15 years without understanding what their obligations are. And now the court's like, well, too bad, it's the right of the child. You shouldn't have waived child support. Now, if we're talking a shared arrangement and maybe the difference in child support payable from one party to the other is like $20, I would even venture maybe $50. If you want to feel like, okay, we want to waive that, then that's fine. But if you have one party that's earning a lot, maybe their child support obligation is $3,000, and the other person's child support obligation is maybe $500, you could see there's a $2,500 spread. Signing an agreement to waive support just because you have a shared parenting arrangement would not fly in that case. You would, if the other person understands their rights at a future date, the fact that you have an agreement that says you waive child support is not going to mean anything. So I am sounding this alarm bell. Be very careful. And when it comes to your parenting plans, you want to be as specific as possible. Now, I kind of look at that as a spectrum, right? The more amicable you are, the more vague sort of the terms can be. And, in those situations, you could, kind of make arrangements as you go. But in a lot of cases, even though people are doing separation agreements and avoiding court, they're not amicable enough for that kind of agreement. And so leaving it open just means leaving yourself open to a lot of conflict over the years. So just determine where pickup and drop-offs are. Pick the time. Like it seems like a little thing, but if you're the kind of if your parties that fight a lot, well, do you want to spend every week fighting over whether the person picked up at 4 versus 5? Like just pick a time, stick to it, follow it. But the whole idea, big picture wise, when you're doing anything that relates to parenting plans, just think about the child's best interest. And part of the child's best interest is ensuring that you guys are not fighting all the time. even you as a parent not being upset at the other party not doing what they ought to do, because what they ought to do is not clear, is also not in the child's best interest. So think big picture, best interest of the child, be as specific as you need to be for your own specific situation. And I'm going to say this again, be careful about waiving child support. So,
I could
yeah.
not agree with those sentiments any more than any other lawyer. So yes, 100%. I think those are very fundamental pieces of advice. And definitely when it comes to child support, even if you're structuring child support in a different way, where it's just like where some party is paying, instead of paying it to you as child support, it's being paid to the child for, their RESP or something of that nature. You want to be very specific about how you got there, what makes sense, and how it's structured, because you don't want to be liable down the line, or have your agreement subject to being challenged because you weren't careful. So I'll leave that. And then lastly, well, not lastly, but another issue is you don't want to sign anything under pressure. So especially in, going through a separation, it's a very, very difficult time. And there's a lot of emotional pulls each way. You're dealing with your financial pieces, you're dealing with parenting, you're dealing with a lot of different changes in your life. You do not want to sign anything in an emotional crisis. Even if you're in mediation or wherever the situation is, you don't want to feel pressured to be able to sign something. That's not how it should be. You should be carefully thinking about the decisions you're making. Of course, we're not telling you to spend years figuring out what a situation could look like, especially when it comes to parenting, because those things can change regularly. But the reality is you don't want to be signing in or rushing into something where you don't have time to really think about the consequences or what you're really signing. So take your
Yeah.
time.
Yeah, sure. And I'll pick it back off that as well and say kind of future proof the agreement, right? So think long term. What happens if, you know, the kids get older? And this is with like younger kids. Do you want to, you could just leave it as is, realizing that you can always renegotiate those parenting terms if there is a material change in circumstances. But if it's something that's foreseeable, like if we are, when I'm drafting agreements, for example, and the children are in kindergarten, I would probably include a review provision for, 2, 3 years down the line, because again, when the children are now in grade school, considerations might change. I might, for the younger kids, sometimes they're in daycare, or for kids even much younger, they're in daycare. And then in a few years, they're in the after school programs of whatever school they're attending. So considerations might change in those circumstances, right? One party that was able to maybe do drop-offs because daycares may be open earlier in the day, but now they don't have that same opportunity when they have to drop the child at school. Things become different. So you kind of listen, and that's the importance of just making sure that you have lawyers that are listening to you. And if you're doing this yourself, make sure that you're kind of thinking about what's in the foreseeable future, and include those review clauses where appropriate. Child support is another one. For the most part, it's not just set on today's income and you're stuck on today's income until that child forever like is entitled to child support. It doesn't work that way. Annual disclosure is required. So do you have provisions in place in your agreement to ensure that there's annual disclosure? If the person is not a regular T4 employee, have you put in mechanisms in place to ensure that, you have a method of calculating their income without having to fight about it every year? Some people just even include things as simple as, grossing up the income by 30% if they know that there's expenses being written off through a business or someone's earning cash income, things like that. So we're just giving you ideas. Obviously, everyone's situation is unique, but we just want you to think about these things, right?
No, absolutely. I think a common like issue that people don't deal with is either if your child is about, 2 years away from post-secondary school, you want to add those provisions in. You don't want to be fighting 2 years after when it's a significant chunk of money that's being required and quite a transition. Or if your child's transitioning out of primary school, what school will they attend? And there's like maybe a year. So like they're not so future forward, but because obviously you don't want to be dealing with if your child's in daycare, what high school they're going to be going to, like, I think that would be a little bit much, but
Mhm.
just those things that you want to give some mind to.
Yeah.
And yeah, another trick or really tip is that you really want to consider the enforceability of agreements and how they are actually enforceable. And that is that they must be in writing and they must be signed and they must be witnessed, and they cannot be witnessed by the person signing or, by a minor. So you definitely want to make sure that all of those elements exist for it to be enforceable. And because the last thing you want to have is like, both of you be on the same page and then you have an agreement and it's neither signed nor, witnessed and nor in writing.
Yeah, no, courts courts want agreements to have some kind of formality to it. And that's why they require, witnesses to be there and all of that. They just don't want people just saying things and it's not clear. So it's simple. Get somebody else to witness the signing, get two separate witnesses to witness your signatures and, just put everything in writing. Sometimes people would say things like, this is what we had on the agreement. And then in addition, there's like oral promises and things like that. That's a very bad idea because a person that's interpreting that agreement would interpret what's written there as sort of the entire agreement. So if there's an additional side deal to that, understand that you're taking a risk of it not being enforceable as well. But
Yeah.
and people would ask like how, when should I involve a lawyer or a mediator? And I mean, my answer is even before you start negotiating, I think at our firm, we're advocates for the moment you start thinking about going through a separation, give us a call because a lot of times people make moves that are not thought out properly. And before you start negotiating, whether out of guilt, out of whatever, and giving away everything, and some, just talk to us so you understand your rights and your obligations, right?
Absolutely.
Okay. So Shereen, I mean, hey, can you think about any more tips? I think we've covered a lot of ideas that people should have in mind if they're looking at getting a separation agreement.
Yeah, I think the only aspect is that if there is a change that does get made to your agreement, just do an amendment to your separation agreement, have that signed, witnessed, and have that done formally. And that will take care of any changes. Don't just leave it up to kind of, goodwill, because that doesn't ever work out most of the time.
Okay, so before you sign anything, I would say as my parting thought would be before you sign anything, get advice. Having a bad agreement can cost you way more than what it would cost you if you had a lawyer draft the agreement for you in the first place. Yeah.
Absolutely.
Okay, and yeah, and if you're not sure, just give us a call. We offer consultations. We could review your draft agreement and make sure that you're protected. So would end it here for now, and until next time, bye bye.
Bye.